Good day, sir. I am Arjun Pakatang, Section D from Group 7, and my co-members are Paglinawan and Pinili. So our topic is all about rules on electronic evidence. So I am the next reporter of Paglinawan, and my topic is all about electronic signature. An electronic signature or a digital signature authenticate in the manner prescribed hereunder is admissible in evidence as the functional equivalent of the signature of a person on a written document. So, very useful po ang electronic signature in the court. Under Rule 6 of Section 2, authentication of electronic signatures. An electronic signature may be authenticated in any of the following manner. A. By evidence that a method or process was utilized to establish a digital signature and verity the same. By any other means provided by law. Or C. By any other means satisfactory to the judge as establishing the genuineness of the electronic signature. E. Disputable presumptions relation to electronic signature. Under Rule 6, Section 3, disputable presumptions relation to electronic signature. Upon the authentication of an electronic signature, it shall be presumed that A. The electronic signature is that of the person to whom it correlates. B. The electronic signature was affixed by the person with the intention of authenticating or approving the electronic document to which it is related, or to indicate such person's consent to the transaction embodied therein. And C. The methods or process utilized to affix or verify the electronic signature operated without error or fault. Under Rule 6, Section 4, disputable presumptions relating to digital signatures. Upon the authentication of a digital signature, it shall be presumed, in addition to those mentioned in the immediately preceding section, that the information contained in a certificate is correct. B. The digital signature was created during the operational period of a certificate. C. The message associated with a digital signature has not been altered from the time it was signed. And D. A certificate had been issued by the certification authority indicated therein. Rule 7. Evidentiary weight of electronic documents. Section 1. Factors for assessing evidentiary weight. In assessing the evidentiary weight of an electronic document, the following factors may be considered. A. The reliability of the manner or method in which it was generated, stored, or communicated, including but not limited to input and output procedures, controls, tests, and checks for accuracy and reliability of the electronic data message or document, in the light of all circumstances as well as any relevant agreement. B. The reliability of the manner in which its originator was identified. C. The integrity of the information and communication system in which it is recorded or stored, including but not limited to the hardware and computer programs or software used, as well as programming errors. D. The familiarity of the witness or the person who made the entry with the communication and information system. E. The nature and quality of the information which went into the communication and information system upon which the electronic data message or electronic document was based. Or F. Other factors which the court may consider as affecting the accuracy or integrity of the electronic document or electronic data message. Rule 10. Examination of witnesses. Storage of electronic evidence. Storage of electronic evidence. The electronic evidence and recording thereof, as well as the stenographic notes, shall form part of the record of the case. Such transcript and recording shall be deemed prima facie evidence of such proceedings. Rule 11. Audio, photographic, video, and ephemeral evidence. Section 1. Audio, video, and similar evidence. Audio, photographic, and video evidence of events, acts, or transactions shall be admissible provided it shall be shown, presented, or displayed to the court and shall be identified, explained, or authenticated by the person who made the recording or by some other person competent to testify on the accuracy thereof. Ephemeral evidence. Section 2. Ephemeral electronic communication. Ephemeral electronic communications shall be proven by the testimony of a person who was a party to the same or who has personal knowledge thereof. In the absence or unavailability of such witness, other competent evidence may be admitted. A recording of the telephone conversation or ephemeral electronic communication shall be covered by the immediately preceding section. If the foregoing communications are recorded or embodied in an electronic document, then the provisions of Rule 5 shall apply. Conclusions. The purpose for the best evidence rule is to help ensure the court receives unaltered evidence that is legible or clearly perceivable in the case of video and audio recordings. That's all, sir. Thank you.